Hello, everyone, and welcome to today's webinar on procedural justice for prosecutors. My name is Alyssa Mark-Haydari, and I'm the Deputy Director at the IIP. I am so thrilled to have everyone with us for this presentation. You should all know this is an hour-long presentation teaser for what's actually designed to be a 4-hour training. Normally, there would be much more discussion and participation, so just so everyone's aware, it's even better than what you'll be seeing today. Before we begin, I'd like to read the IIP's Land Acknowledgement Statement. We want to acknowledge that the IIP is based in New York City, which is Lenapehoking, the Lenape homeland. We honor all of the indigenous nations and their land with great gratitude and acknowledge the genocide and continuous displacement of indigenous peoples. We also acknowledge that enslaved Africans whose labor built Manhattan during the colonial era and beyond. We acknowledge the harm inflicted upon the indigenous communities and people of color across this country, which inspires IIP's ongoing work. Now, one more thing before we kick off the webinar, there are a few housekeeping items. First, the link to the full training curriculum, including handouts, and today's webinar are going to be made available on the IIP website at www.prosecution.org under the Tools tab. We've also added all materials through the attachment tabs at the bottom of your screen. During this presentation, we will use multiple live polls to provide for your input throughout the session. Instructions on how to access the polls via text and web will be provided on screen momentarily, and they'll be placed in the chat. We'd love to hear from you from today's presentation. If you have a question for our speaker, please feel free to send it through the Q&A tab at the bottom of your Zoom screen. We'll be answering all questions at the end of the session. And if we don't get to your question during today's webinar, we will be sure to follow up via email if possible. Now, without further ado, I'm pleased to introduce our facilitator, Chloe Akar from the Center for Court Innovation. Chloe, take it away, please.
Thank you so much, Alyssa, and good afternoon or good morning, depending on where you are. My name is Chloe Akar, and I am the Director. I am the Director of Community Technical Assistance at the Center for Court Innovation. I am joined today by my colleagues, Brett Taylor, who is the Senior Advisor, and Caitlin Flood, who is a Senior Program Manager, both on the National Training and Technical Assistance teams for the Center for Court Innovation. For those of you who are not familiar with the Center, we are a New York City-based nonprofit operating in 3 buckets. We conduct original research to evaluate legal systems and determine what is working and what is not. Secondly, we use operating programs as incubators to test innovative practices with the aim of improving those systems. And then third, we provide national and international training and technical assistance to share best practices and assist jurisdictions in adjusting and adapting our programs to fit their unique needs. At this time, we're going to insert a live poll to ask folks in the audience where they are. We'd love to have the opportunity to learn a bit more about who is in the audience. So please text CTA 866 to number 22333, or you can visit www.pollev.com and type in CTA 866. These instructions have also been placed in the chat. And so as we wait to see where everyone is joining from, I can get started discussing our first part of this training. And so before getting into the key principles of procedural justice and how prosecutors can incorporate them into their practices, 2 short videos, or actually 1 short video is going to be shown. The video was created by Equal Justice Initiative and draws a distinct line from slavery to the era of mass incarceration. And the video may be disturbing to some and may make others uncomfortable. We believe that you cannot begin to understand the concepts of procedural justice and how its practices can make the legal system open and fair to all until one understands how the system evolved from its founding to where it is today. Video is being shown just to ground this conversation.
In 1619, when the first Africans were brought to the British colonies by ship to Jamestown, Virginia, they held the legal status of servant. But as the region's economic system became increasingly dependent on forced labor, we descended into slavery. The institution of American slavery developed as a permanent, hereditary system centrally tied to race. Millions of black people were forcibly taken from Africa, crammed on ships and brought to the Americas through a dangerous and deadly journey that crossed the Atlantic. Millions died. Once on our shores, slavery deprived the enslaved person of any legal rights or autonomy and granted the slave owner complete power over the black men, women, and children legally recognized as property. An ideology of white supremacy, a narrative of racial difference was created to rationalize and justify the continuation of slavery. American slavery was often brutal, barbaric, and violent. In addition to the hardship of forced labor, enslaved people were maimed or killed by slave owners as punishment for working too slowly, visiting a spouse living on another plantation, or even learning to read. Enslaved people were also sexually exploited. The United States Congress finally banned the importation of slaves from Africa in 1808. Slavery was widely considered a gross human rights violation, yet enslavement was retained and persisted. The 1808 Declaration caused the demand for slave labor to skyrocket in the Lower South, and the domestic slave trade grew to meet this demand. Between 1808 and 1860, the enslaved population of Alabama grew from less than 40,000 to more than 435,000. Slave traders chained African Americans together in couples and forced them to march hundreds of miles from the Upper South to the Lower South. Steamboats carried slaves along the Alabama River. Rail routes constructed with slave labor brought hundreds of enslaved people to Montgomery, Alabama every day, turning the city into one of the largest slave trading communities in the United States. Enslaved people would be paraded up Commerce Street to slave warehouses and slave depots. The city's slave market was at the Artesian Basin, now known as Court Square. Enslaved people of all ages were auctioned along with livestock, standing in line to be inspected. Public posters advertising the sale of slaves included gender, age, skill, complexion, owner's name, and price. Slavery in America traumatized and devastated millions of people. Husbands and wives, parents and children could not protect themselves from being sold away from each other. Enslaved families were separated at an owner's or auctioneer's whim, never to see each other again. The domestic slave trade separated nearly half of all enslaved people from their spouses and parents. In 1833, the Alabama legislature banned free black people from residing in the state, meaning that enslavement was the only legally authorized status for African Americans. Even as the Civil War raged, slave trading in Montgomery flourished well into the mid-1860s. After the Confederacy's surrender in 1865, Congress passed the 13th Amendment, which prohibited slavery nationwide except as a punishment for crime. But in many former slave states, slavery did not end. It simply evolved. Southern whites, angry after losing the war, targeted black people who were largely abandoned by the federal government in the 1870s. For decades, black men, women, and children were tortured, terrorized, and killed by mobs and violent lynchings, oppressed by a system of racist laws and customs. For another 100 years, black people were racially segregated, denied the right to vote, education, and basic dignity. They were humiliated, beaten, or killed for minor offenses or for protesting. The civil rights movements of the 1950s and 60s helped to end legally authorized racial segregation, but racial bias still persists. Today, a presumption of guilt is assigned to many people of color who are disproportionately arrested, convicted of crimes, and sent to prison. African Americans are 6 times more likely to be sentenced to prison for the same crime as a white person. 1 in 3 black males born today can expect to spend time in prison during his lifetime. Police violence against black people is so epidemic that civil rights demonstrations have shut down cities across the U.S. as thousands of people march to protest police brutality. Many states celebrate the era of slavery with Confederate holidays and by honoring the defenders and architects of slavery while ignoring the history of enslavement. The Equal Justice Initiative believes that racial bias remains a serious problem and is a direct and lasting legacy of American slavery and our failure to deal with the history of racial injustice. The Equal Justice Initiative seeks to foster an honest conversation about the legacy of slavery, about mass incarceration, and racial inequality and how it still affects millions of people today.
And so at this time, we would like to ask everyone to use one word to describe how this video relates to your job as a prosecutor. And all of these answers are so amazing, right? Context, history, racial being the major ones that everyone is seeing. Justice, violence, reflective, policing, bias, right? These are all amazing, amazing answers. And so please continue to add more of your thoughts as we move forward. So what is a prosecutor, right? The American Bar Association defines a prosecutor as an administrator of justice, a zealous advocate, and an officer of the court. And so here I want to really have you guys think about what the words administrator, advocate, and officer have in common. And perhaps there are words that are in this definition that are missing to you in this role. And so the common thread between administrator, advocate, and officer is legitimacy. In order to be an effective administrator, an effective advocate, and an effective officer, you must be seen as legitimate when you are exercising your authority. And so the questions to start wondering are, how does the lack of legitimacy, or how does having legitimacy affect your ability to perform in your role? Right? How does it affect the way the public views your office and your position? Right? The court, jurors, defense bar, the accused individual, anybody that is in the audience, in the courtroom, all of them have to see you as legitimate in order for you to be effective in your role. And so views about legitimacy have been found to be rooted in the judgment that the police and the courts are acting fairly when they deal with community residents. And so Tom Tyler, who is a professor at Yale University and is known as kind of the godfather of procedural justice, has performed over 3 decades of research into procedural justice theory and its application in law enforcement and court settings. And Tyler has found that fairness, right, is at the root of community perceptions regarding legitimacy. And so this perception is inextricably tied to being seen as legitimate or how fair you're being perceived to be. So what does fairness mean? What is supposed to be fair? And to whom are we supposed to be fair? And then how do you even show that you're being fair? You want to think of this chart as your Yelp review. The Center for Court Innovation conducted a 2-site study in Cleveland, Ohio, and Newark, New Jersey, of high utilizers of the criminal justice system. These are individuals who have had numerous contacts at the local and state level. And as this chart provides a lot of information, it is recommended that these key findings be highlighted. Satisfaction with the criminal justice actors is built independently. And that's the major takeaway from this chart. What this is showing you is that individuals who are having contact with the justice system are gauging each contact separately. Unlike how most of us feel or think that the criminal justice system is just kind of a whole and is analyzed as that whole, right? And so regardless of how you feel about police, you probably feel similarly about judges and defense attorneys. However, what this is showing us is that individuals who are coming in contact with the different touch points in the justice system are all developing specialized trust and satisfaction ratings with each person. And so think of it as your Yelp review, right? As you move through, the Yelp review can either go up or down. And that's the highlight of this, right? The highlight here is that prosecutors have the power to influence their own Yelp review separate and apart from the contacts that an individual may have with other actors in the justice system. The second thing that you want to note is that prosecution or prosecutors are linked to the police in terms of satisfaction rating, right? And so Kim Fox mentioned that prosecutors and police are inextricably linked together during a previous webinar. And the going hand in hand relationship may be something that causes the trust factor or satisfaction rating to effectively link to the other person. So if you have a negative encounter with a police officer, that might negatively influence how you perceive your satisfaction with a prosecutor. But again, going back to my previous point, the highlight in this is that you can actually separate yourself from that interaction with the police and increase your own personal Yelp rating. And so knowing that, what is the effect? The effect of prosecutor satisfaction ratings are resounding, right? So this graph demonstrates that the impact of mass incarceration is huge when you think of it in terms of the number of adults in the United States that can be impacted by your one negative Yelp rating. So it's very much like the, I don't know, restaurant down the block from me. I put in a negative rating and everyone else in my neighborhood that is available, that, you know, looks at Yelp like some folks do, would be able to say, oh, they got this really negative rating and it can have an effect on whether they go there. And then next week when a friend is looking for a restaurant and mentions it, that person who read my rating may say, oh no, I read something negative about them on Yelp. And so that has, my negative rating has now affected 2 other people. And it can continue to extrapolate in that way. And so that's the thing that we want to stop, right? So procedural justice is the perceived fairness of procedures and interpersonal treatment. It's used to build trust between system actors and those that they encounter. And so during Tom Tyler's studies, over 20 common elements were present during interactions that were perceived to be fair. Of these, the top 4 elements that were present in the overwhelming majority of Tyler's research were respect, voice, neutrality, and understanding. These elements are known as the principles of procedural justice. And procedural justice theory has come under a lot of scrutiny, as most attempt to oversimplify it as what your grandmother taught you. However, the key to the effectiveness of procedural justice is ensuring that you have all 4 elements present during each interaction that you have. And that may seem onerous, and that is because it is. It isn't just simply what your grandmother taught you. So while that may seem simple, for prosecutors, it becomes much more complicated because of the constraints that come along with your position. And so what are these elements, right? The theory states that people are more likely to accept decisions when they see system actors demonstrate respect by treating individuals with dignity and openly protecting their rights without sacrificing accountability. So an example of that would be individuals perceiving that a judge or attorney and court staff treat them with dignity or respect. Voice is found when there is an ability for a witness or a victim to participate in their case by expressing their own viewpoints, allowing them the opportunity to feel heard. Neutrality is present and demonstrated when legal principles are consistently applied by unbiased decision makers who are transparent in how these decisions are made. And then understanding is found where you are providing understanding to individuals regarding the court process, any documents that you are providing them, for those to be written in a way that allows them to really fully understand. If you're writing or providing information in multiple languages, to ensure that the person that is receiving information is receiving it in the language that they are most comfortable in when developing an understanding of things. And then, so I just want to note at this point that procedural justice focuses a lot on perception, right? It's a lot about the perception of there being respect and the perception of voice or neutrality and understanding. And I want to say at the outset that changing perceptions doesn't actually change the justice system. And these 4 principles alone will not make the justice system fair. And so we just want to note that at the outset. But what it can do, and what implementing these practices into your office culture, as we'll discuss in a moment, can increase the amount of trust that your office has with the communities that it serves. Again, the aim is for you to be able to increase your individual Yelp rating with the community at large. And so when I say, the community, who am I talking about? The importance of procedural justice is that its application affects every single person that you come in contact with. Whether you are on the clock, walking, to or from court, washing your hands in the courthouse restroom, picking up your coffee in the morning, or enjoying a happy hour drink at a local pub after, use of procedural justice principles isn't relegated to your victim and witness, but also to the accused, to the defense attorneys, the judge, court officers, court admin staff, and anyone in the audience and community at large. And so what is the benefit of procedural justice? Some of the benefits are that you can increase public trust in the system. You are increasing the likelihood of reporting future crimes because now the community at large has built trust in the system and believing that the outcome of that reporting is going to be just. You increase cooperation with law enforcement. Court appearance rates go up because there's a trust in the system and what is happening at court. Compliance with court orders and the law will be increased, and then just a general understanding of legal processes and expectations. So if you really think about it, a lot of the confusion in what's happening, in prosecutors' offices, in law enforcement in general, is that there's just a lack of understanding of processes, and wanted to make sure that everyone's expectations are set at the outset of the contacts. And then you have increased decision acceptance, right? Studies in other industries have also shown increased customer satisfaction with both the process and the outcomes, such as like service industries where procedural justice practices have been incorporated. And there's also an increased customer satisfaction with the treatment they receive and the outcome. Again, all lending themselves towards an understanding that you can increase decision acceptance. And so one of my favorite slides here, right? Everyone's heard the adage, organizational culture eats strategy for breakfast, lunch, and dinner. And so what are we talking about when we're saying culture eats strategy, right? We're gonna talk about how applying the 4 principles of procedural justice, respect, voice, neutrality, and understanding at 3 major touch points in a prosecutor's career can be navigated, right? So victim witness, the accused, and the community. At those 3 touch points. Since culture eats strategy for breakfast, we're gonna focus on how to make changes in office culture that promote procedural justice. Because regardless of the strategies you choose to undertake, even those suggested in this training, if you don't have proper office culture, the strategies just aren't going to work, right? You actually have to ensure that the strategies, that the office culture is changing in order for there to be an actual increase in your trust meter. So what are some suggested practices, right? Taking each element at a time. Respect. Limit the number of times a victim or witness is asked to recount events. You don't need to read unnecessary incendiary details at arraignments. You can support local businesses, right, in your jurisdiction and the services that they provide. And so what would that look like, right? Limiting the number of times that a victim or witness is asked to recount events goes towards respect, in that you are respecting their time, you are respecting their emotions, their privacy, wanting to ensure that their recounting of the events doesn't cause added trauma or harm to them. Removing unnecessary incendiary details at arraignments allows for removing some of the dignity stripping moments from that point in time, right? At that point in time, the individual before the judge is being assessed to determine whether bail needs to be set, right? And then you want to ask whether these unnecessary incendiary remarks are being used in order to influence the bail determination, in which case, depending on the state that you're in, that is an improper use of your bail application. And so you really want to ask yourself, why am I saying these details? And then supporting community-based organizations in your jurisdiction shows a respect for the community in which you are served, in which you're serving. And so that could look like using alternative to incarceration programming that's based in the community to ensure that individuals that are going towards these programs or being sent or mandated to these programs are doing so in a space that is culturally responsive to them. Incorporation of voice can look like asking the defense attorney or the accused, if they're pro se, whether they have information that you should consider. And that can look like asking if there's a mental health issue that should be considered, or if there is a substance use issue that may be considered, in order to determine how you should proceed with the case. Not leading the victim or witness when they recount the incident, oftentimes, and in my experience as a baby prosecutor, I found that there would be a lot of moments where if you are speaking with a victim or witness on the phone and you also have to run to court and there's a lot of things that are kind of going on around you if you're prepping for a trial, there's a tendency to ask leading questions of victims or witnesses to be able to pull out the story expeditiously. So wanting to make sure that you're not doing that to allow a victim or witness to feel like they actually had the opportunity, or to give them the opportunity to tell their story, however that needs to come out. And then routinely asking for community feedback about the policies and practices in your office. And this is going to relate to some other principles like neutrality and understanding, because what you do is you need to provide the policies and practices of your office outwardly. Let the public know what they are, and then allow space for community feedback. In terms of neutrality, you want to make sure that you're not using accusatory language. You want to ensure that you are consistent in the courtroom decorum on and off the record with all parties. And consistency in courtroom decorum may look like not being overly friendly with your counterpart on the defense bar, even though that may be your best friend. Provide information on decision-making for high-profile cases, and we've seen this a lot lately for high-profile cases, and it doesn't have to always come in the form of a press event. It can, maybe there's press briefings that are on your website or that are shared with the community at council meetings. And then lastly, understanding. You want to provide the victim or witness with step-by-step information on what to expect when navigating the system. There are a lot of misconceptions in the community about what the system is actually doing. What happens after a case is filed? What happens after arraignment? How long does it take to get from arraignment to trial? What is happening in the middle of those things? What is discovery, and what is going to be shared, right? There are a lot of things that are happening in between all of these different really key steps in the justice system that individuals may not be aware of, understand, and you want to be able to give them that information in plain English. Openly share data on case dispositions and use of diversion, alternative to incarceration programming with the community. This allows the community to be able to see exactly what is happening in your office and kind of pull back the veil a little bit. That will go a long way in order to receive the feedback that was mentioned earlier in voice. And then lastly, provide defense attorneys with reasons when alternatives to incarceration are not available, right? Oftentimes, offers are made with a very specific intention or having very specific knowledge on the side of the prosecuting agency, and you want to be able to provide a reason to the defense attorney, and not so much to give away your strategy or give them an opportunity to figure out how to retort, but what you want is to provide defense attorneys with the reason, because they are going to say it to their client. And so what you want to do is find ways in which you can provide information to the defense attorney so that they can then go and help their client understand why certain things may not be available to them at that time. And then we also want to take the time to highlight the intersection between procedural justice and trauma. There are 4 ways that the body reacts to danger, stress, and trauma. And these responses are controlled by your brain's autonomic nervous system and are essentially survival mechanisms to help us cope with actual threats or perceived threats. And so one of the recommendations that we have is that you operate under a universal expectation of trauma approach. And that means that anyone in the system or program, no matter what their position is, whether they're people who use services or if they're staff or you yourself, everyone can be a trauma survivor. So we're encouraging that you identify how your own values, biases, and triggers may affect your behavior and communication, both in court or in the office when you're reading over a new case file. And then you want to rely on the tools at your disposal and your relationships with court parties to ensure that if you see someone in court that is having one of these reactions, that you take the appropriate steps in order to give that individual an opportunity to come out of that trauma response state. And that can look like asking for a second call in jurisdictions that use second calls in order to allow the defense attorney to speak with their client, pull their client aside, and do a check-in to make sure that that individual is okay to continue. And so at this point in the training, following several other slides, we would go into breakout sessions. And the breakout sessions are designed to be an opportunity to provide training participants the time to work through several scenarios together in groups and apply some of the principles that were discussed to actual scenarios. And so we are going to attempt to do a condensed version of the breakout sessions with all of you today. And so please bear with me if there are any technical issues. Here is our first scenario. You are picking a jury and you want to make sure that the jury knows how dangerous the accused is, in your opinion. Do you call the accused Mr. or Mrs. and then say their last name, or do you call the accused the defendant? Another question that would be asked at this time would be, does your answer change if you know that the accused's family is in the courtroom? What is the effect of calling the accused the defendant? And then what do you lose in calling the accused by their name? And so you can see the results right away. This is awesome. 56% of those of you who are on and participated said you would call the accused Mr. or Mrs. and their name, as opposed to the 44% that said you would call the accused the defendant. And I just want to note that these scenarios are meant to cause discussion and real kind of sharing of ideas and explanation on several pieces of the justice system that may not be talked about often, right? When I started my job as a prosecutor, or even when I was in law school, no one ever said why we call them the defendant other than the fact that they're defending themselves in court, right? But like, why do we do it, right? What does it mean to do it? And so the scenarios are meant to bring out really thoughtful conversation and questions in a space where there is no judgment, and in a space where everyone is there to kind of grow and learn together. So the next slide. So this is our second scenario. You're walking back to your office after spending the morning waiting for a trial to start. Your colleague makes a racially disparaging comment about one of the accused men in your case. Does your response depend on your colleague's racial background? Yes or no? And so the second question on this part is, does your response depend on your colleague's, oh, sorry. The first question would have been, what do you say to your colleague? So if you're going to say something, what would you even say, right? And this, again, goes back towards culture. You want to ensure that the office culture is consistent, right? And so if you are operating in an office where this type of communication is frowned upon, aside from the potential EEO issue that's present, you want to make sure that everyone in the office would be comfortable letting their coworker know whether the comment was inappropriate. And again, meant to be thought-provoking. So great. At this time, and thank you everyone for responding. 18% of you said yes, that your response would depend on your colleague's racial background, and 82% said no, that it would not depend on the race of your colleague. So now I would love to launch into Q&A. If there are any questions in the Q&A.
Thank you, Chloe, for that wonderful presentation. I'm going to leave the Q&A up for a bit. One person asked, is structural racism an issue? I think the question probably is asking just something that is touched on in the training material. So maybe you can talk a little bit about that. I think the answer is yes, but I'll let you elaborate more.
Yes, thank you for the question. So structural racism is an issue. There's no way around that, especially in the way we design this training to be. So if this training is provided by design, it would go through a module, the first module, in which you learn about the connection between slavery to mass incarceration, which is the video that I showed at the beginning of this presentation. And then there is a second video that walks you through the structural racism and how it affected the war on drugs. And then following that, there's a series of slides that we would walk through that show the impact of racism on structural racism on the perception the community has on, or folks in the country have on, prosecutors. And then there's a slide that directly depicts that regardless of whatever cross-cut of the country you do, the majority of folks in that cross-cut find that the system is racist against minorities, specifically African Americans.
Thank you. Keep the questions coming, everyone. One question I'll ask is, who is the target audience within a prosecutor's office? Is it first years? Is it mid-level? Who are you generally hoping to receive this training?
Yeah, thanks, Alyssa. Great question. I think that the training is open for everyone. I think the training, if you really want to make culture change, excuse me, it can't be a bottom-up approach. So this isn't the type of training that you can expect your baby prosecutors to come into and have that change culture in your office. It needs to be approached top-down. It needs to be approached sideways. It needs to be approached bottom-up. Culture change is actual work that needs to happen, and it doesn't come easily. And it's not going to take just one training. This one training isn't going to create culture change. And so one of the wonderful things that we incorporated into this training, in my opinion, is that there are takeaways at the end of each module that prompt the attendees to really think about what are they going to incorporate? What did you learn from this training that you are sharing with those that are in your office with you? What practices can you do in your office to make changes that incorporate respect, that incorporate understanding, and that incorporate, you know, all of the elements into how your culture is going to shift moving forward? And I can share that we beta tested this training several times over the last 2 months, and the feedback was really, really amazing. We've done it now, I think, with executive leadership, and we've done it with baby prosecutors. And I honestly can say that the conversation that happened at the executive level was riveting. Great engagement, especially over Zoom, which can be really difficult, as you all know, during these COVID times. Wanting to really dig deep into some of the proposed applications of procedural justice, but then also the training allows for a lot of opportunity for prosecutors who are attending the training to give back ways in which that you do these elements, right? Like every prosecutor here on the call today knows how to give respect. You inherently do it in your job. There's no way you haven't done it. And so it isn't a judgment call on anyone. It's a matter of let's extract the policies and the things that we are doing that we know are working, and then how can we potentially incorporate some of these other suggested practices to affect real culture change in the office.
Thank you, Chloe. Are there other procedural justice trainings out there for prosecutors? And if so, how would you say this one is different?
There are other procedural justice for prosecutors trainings out there. I think this one is different because it focuses more on culture change and practical applications as opposed to focusing on perception and the strategies that can be used to change perception. I attempted with IIP to really strip the perception language from the training in order for it to be concrete and applicable suggestions that can be made that not only change the perception of fairness, but also change your office's culture.
And another question I see in the chat is, what would you say about the need for a training to a prosecutor's office that might be a lot less receptive to this kind of material, perhaps doesn't think systemic racism is much of an issue? Any thoughts on perhaps less receptive offices and audiences?
Yeah, I think that this is a perfect training for that audience. I would caution anyone from wanting to stray away from a training that is going to confront an issue that we know to exist, just because the audience may shy away from having that conversation or doesn't want to have that conversation. I think that part of creating culture change is creating person change, it's people change. And you're not going to be able to do that unless you're actually having conversations based in fact. I think one of the ways in which you can make the training more palatable or more receptive is to provide data from your office in showing the potentially disproportionate way your system is working, and then using that as the basis for why this training is being provided.
Thank you, Chloe. I think that's a great answer. I don't see any other questions at this point. I just want to thank you so much again for giving the presentation. I've seen Chloe give it several times. She's awesome at it, whether it's an hour or the whole 4-hour presentation. She's wonderful, and the materials are great. So Michelle put in a link to the materials in the chat. And also, just so everyone's aware, we at the IIP, we're hosting another panel on a very different topic. It's on human trafficking at 5 o'clock today. Michelle, if you could please put that registration link in the chat so that people can join. It's 5 o'clock, it's after work hours, but I promise you it's a very good informative series that we've been putting together. So I just wanted to thank CCI for everything that they've done. The materials are wonderful. Chloe, you're great as always. And I hope everyone has a wonderful rest of their afternoon.
Thank you.